Welcome to my channel. Please like, comment, and subscribe. Florida offshore injury lawyers. Offshore workers often face workplace dangers. Though these employees play a key role in the U.S. economy, they encounter risk work environment. Offshore workers are 7 times more likely to be killed on the job than employees in other industries. When a worker is injured or killed on a job, the employee and their family may struggle on top of medical bills. The worker has likely lost the ability to earn necessary income. All the while, oil industry employers try to blame the workers for the accident and avoid paying compensation. If this sounds like an overwhelming situation, it is, however, you do not have to handle an offshore injury accident alone. If you are injured or you lost your loved one in an offshore accident, you need a knowledgeable maritime accident attorney on your side. A Florida offshore accidents lawyer are committed to protecting your rights. You don't want to fight the powerful oil industry in your own. An offshore injury attorney can help you understand your rights and fight for the compensation you deserve. It is important to hire a maritime injury attorney who understands the detailed sentences, uh, the detailed differences between maritime law and land-based employment law. When an accident occurs at sea, international, federal, and local laws may all apply to your case, so you need a team of attorneys experienced in personal injury litigation fighting for you. Maritime law is on a system all its own, and you should trust your claim only to someone with a plenty of experience in this field. At a cruiseman attorneys at law, we have been helping employees who experience catastrophic accidents for decades. Here, we will share an overview of offshore workplace injuries as well as the legal remedies available to offshore workers. If you have been injured in an offshore accident, our experienced maritime lawyers are ready to help you get the compensation you deserve. Contact us today to get started. What causes offshore injuries? A dangerous maritime environment and combined with heavy equipment and explosive chemicals creates the possibility of workplace accidents. From transportation to the workplace to dangerous conditions on site, offshore workplaces are riddled with potential hazards. Here are some of the causes of offshore injuries. Explosion, when chemicals builds up in enclosed spaces or combined with other substances. Fires, when combustible materials ignite. Slip and falls on wet surfaces or unstable platform. Machinery malfunctions from manufacturing defects or worker error. Exposure to toxic chemicals involved in oil extraction and enclosed spaces that increase the risk of an injury in an accident. While not all offshore injuries are preventable, workers often suffer the consequences of employer negligence. Your employer has the duty to provide a safe work environment, and when you face unsafe conditions, your employer could be liable for the harm you suffer. What injuries do offshore workers sustain? Dangerous offshore work environments can lead to life-altering injuries, including these: burns, severed limbs, traumatic brain injuries, broken bones, tissue damage, internal organ damage, neck injuries, spinal cord injuries, respiratory problems. Unfortunately, not all maritime workers survive an offshore accident that result in injuries. The severe nature of many offshore accidents means that maritime workers are killed each year. What legal options are available to offshore injury victims in Florida? An injured offshore worker has several legal options depending on the specifics of the accident. Maritime injuries are governed by different laws than land-based injuries. So, a traditional workers' compensation attorney might not know how to help. However, other grossman attorneys at law, we know maritime law and use our insight to fight for your maximum compensation. Maritime law, also referred to as admiralty law, governs activities on navigable waters. Navigable waters include any body of water capable of being used for interstate or foreign commerce. For example, a river running across state lines in navigable water governed by maritime law, but a lake solely within a single state is not. Maritime law encompasses international, federal, and local laws. When you are injured while working at sea, our maritime injury lawyers will evaluate two primary methods of compensation. Maritime common law. Under maritime common law, a worker injured at sea is entitled to maintenance and cure. You might compare these payments to what a land-based worker receives from workers' compensation. Maintenance is your daily living expenses, such as room, board, food, and transportation. Cure is any necessary medical expenses associated with your injury, such as hospital and doctor bills. Surgery expenses, prescriptions, medical equipment, and testing costs. Maintenance and cure provide significant compensation, but it can have one advantage of maintenance and cure is that is no fault system of compensation. It allows for payment for injuries and even disease or condition that arises while in service of the vessel. This means that even if you are responsible for your accident, you can still claim compensation. And then the next is Jones Act lawsuit. This Jones Act is a federal law that gives maritime workers the right to sue their employers for workers' injuries. To file a lawsuit under the Jones Act, a worker must be classified as a seaman. To be classified as a seaman, a worker must meet these requirements: contribute to the operation of a vessel on navigable waters, and spend 30% or more of her work time in the service of a vessel. Employees such as ship crew, fishers, cooks on a vessel, all rig workers, and others may be considered seamen under the Jones Act. Jones Act negligence. A lawsuit under the Jones Act is fault-based. This means that you must prove that your employer's negligence caused your injury. If you were entirely responsible for your accident, you cannot sue under the Jones Act, but if your employer is even the slightest but negligence, you might still recover. This means that maritime lawsuit requires evidence of wrongdoing, which is not necessary to claim maintenance and cure. Jones Act damages. However, a Jones Act claim can provide you with substantially more money. Under the Jones Act, you can recover for economic and non-economic damages too. I think that's all, guys, the information that I can share to you. Thank you so much, guys, for watching, and if you need information related to maritime topics, you are in the right channel, because in this channel we talk about it a lot. And then if you guys want us to talk about or discuss about information that you need about maritime topic, you are in the right. You can just drop your comment below in the comment section, guys. Later when we have a chance, we will talk about it. I think that's all the information that I can share to you. Thank you so much for watching. Don't forget to give like, comment, and subscribe. Bye bye.